Good afternoon, everyone, and thank you so much for joining us for today's event, What Comes Next for the Supreme Court? My name is Sadia Sindhu, and I'm the Executive Director of the University of Chicago Center for Effective Government. And I'm thrilled to have the chance to kick off this important and timely conversation. At the Center for Effective Government, we work to bring scholars, students, and practitioners together in the interest of thinking through difficult challenges facing our democracy and impeding our government's ability to solve public problems. And we work towards finding reasonable, practical, evidence-based solutions to these challenges. In recent years, as we watched confirmation battles unfold, landmark opinions handed down, and most recently, a leak that previews drastic changes to abortion and other rights to privacy, it's clear that the Supreme Court, its inner workings, its structure, and its interactions with other government and entities, entitled and the American people, is yet another battleground for democracy and effective governance. There's a lot to get into today, but throughout the conversation, we'll discuss not only reactions to recent events, but we'll explore concrete ideas for reforming and improving the Supreme Court as an institution, unpacking the trade-offs and their effects on the overall strength of our democracy. We're so lucky to have an all-star panel with us today with deep expertise in law, advocacy, and governance, who can all shed light on these important issues. Before I turn things over, I want to say thank you to the co-sponsor for today's event, Democracy Fund. Democracy Fund is a critical voice in the space and a steadfast supporter of organizations working to strengthen democracy through our elections, governance, civil society, and in the public square. We're grateful for their partnership on this and throughout all of CEG's work. I also want to remind our audience that we will leave a few minutes at the end of our discussion for your questions. Remember to submit questions using the Q&A function if you're joining us on Zoom, or in the comments section if you're watching this on YouTube. We'll try to get to as many of your questions as we can. With that, I'm thrilled to introduce our moderator for today's discussion, Rudy Marbani. Rudy, we're so lucky to have Rudy. He is the Senior Director of the Governance Program at the Democracy Fund, and he joined CEG this year as a 2022 Senior Practitioner Fellow. Prior to Democracy Fund, Rudy served as an assistant to President Obama and as a director of presidential personnel. He was a member of the White House Transition Coordinating Council. As an associate counsel and a special assistant to the president, he also was leading the team responsible for vetting executive nominees and appointees. He has also served as general counsel of the Peace Corps during the Obama administration. His work during his fellowship considers how people in government and the rules governing their appointments and service can act as a bulwark against abuse, as well as foster a welcoming and empowering place for people of diverse backgrounds to become the next generation of public servants. We're thrilled to be housing this work at the Harris School of Public Policy. Rudy, it's so great to have you leading this discussion today, and welcome. I'm going to turn things over to you to introduce our panel.
Thanks, Sadia. Thank you so much for hosting this event. It's a pleasure to participate in it and to work with you and your team at the center. So as she said, we have an all-star panel today to discuss these important issues. I'll introduce them one by one. I'd like to begin by introducing Sarah Binder. Sarah, thanks for joining us. Sarah is a senior fellow at the Brookings Institution and a professor of political science at George Washington University. She specializes in Congress and legislative politics. She's most recently the co-author with Mark Spindle of The Myth of Independence, How Congress Governs the Federal Reserve. I'm very excited to have you. Joining Sarah is my friend Chris Kang, who is the co-founder and chief counsel of Demand Justice. He served in the White House for nearly 7 years as deputy counsel to President Obama and special assistant to the president for legislative affairs. Chris oversaw the selection, vetting, and confirmation of more than 220 of the president's judicial nominees, who at the time set records for the most people of color, women, and openly gay and lesbian judges appointed by a president. I'm also thrilled to welcome Fatima Goss Graves. She is the president and CEO of National Women's Law Center. She is a nationally recognized leader in the fight for gender justice and an expert in law, policy, and culture change. So welcome, everybody. Thanks for participating. So I'm going to jump right into things. As Sadia mentioned, the news is rightly focused on the leaked draft of Justice Alito's opinion in the Dobbs case and the profound implications of that opinion on abortion rights and by extension, all protections stemming from the right to privacy and other unenumerated rights. And these are important topics, and I promise to get to them. But before jumping in right there, I want to start on what I think is a positive note, and that's the historic nomination and confirmation of Judge and Justice Designate Ketanji Brown Jackson. Now, I'd like to just ask the entire panel, reflecting on Judge Jackson's recent confirmation process, I'm wondering what you think will be most remembered from her confirmation hearings. And if you want to give a prediction for what you think will be the most significant impact of her confirmation on the court, I'd welcome that too. Chris, why don't we start with you?
Sure. I mean, I think there's a lot to take away from this historic moment for the first time in our country's history to finally have a Black woman Supreme Court justice. I also think it's going to be important that Justice Jackson will be the first justice with experience as a public defender, representing people who can't afford a lawyer and have been accused of a crime. We have not had a justice with any criminal defense experience in 30 years since Thurgood Marshall retired. And I think bringing that perspective and that experience of sitting across the table from real life individuals and not, just having your clients be the government or corporations will bring a different perspective. And I really think that as we think about the impact that Justice Jackson will have on the court, it's hard to say how much impact she will have from a jurisprudential perspective, because there are still 6 Republican appointed justices. But I do think that the tenor of oral arguments, the kinds of opinions she writes, and I also think it'll be interesting to see all 3 of the Democratic appointed justices are women. And I think that could change a little bit of the dynamics and the back and forth and perspective on the court. But I'd be interested to hear Fatima's perspective on that as well.
Yeah, I'm happy to jump in. I totally agree with everything that Chris said. I'll add a couple of other things around the confirmation process that I think will be remembered. I think all people will remember her sitting there so stilly in the face of unprecedented attacks. I think that's going to be a legacy that people take with them and think about when they see her sitting and take her seat in October. And there's something there about the power of the folks who demanded that the president actually put a Black woman in the seat, the power of sticking with her through a process that was really, really difficult for people, felt very personally for many of us watching it. It was really hard to watch. It took many of us back to our own personal experiences. So I actually think there will be an important symbolic moment in October when she takes her seat for the first time that will be galvanizing for this country. I also think it's going to really matter that the 3 are women. I think it'll shift how people think about the court as a representation in this country. I also think one of the things that has been useful about COVID is the fact that arguments stream live and you can hear people's voices and the types of questions they are asking, and the public has more access to the court, which I see as a very good thing. I think it will also expose a lot of people, including non-lawyers, to the idea of the court and the decisions it makes. And then one more thing, I said last thing, but one more thing. These are generational appointments. And I'm thinking about how it used to be that Justice Thomas was perhaps by himself or sometimes with Justice Scalia, writing dissents that were nowhere to be found either in the other case law, but they had no partners with them. And now we are in a situation where their early perspectives and voices are the majority of the court. And that feels some days like that happened in a blink of an eye. And I understand that these decades are long, but he has now found his company.
The only thing I would add in terms of kind of the takeaway from the Jackson confirmation hearing is just the dropping out or the disappearance of support from the Senate opposition party, regardless of who the nominee is. And This wasn't quite the Amy Barrett confirmation vote, where first time, I think, since the late 19th century, there were no opposition party senators voting for confirmation, right? But they were all but, right, just a handful, 2, 3, I think the 3 Republican senators willing to cross the line there. And to some degree, I think we reflexively think about this as just like the ideological differences between the two political parties and who they want to see or not see on the bench, and we can come to why that's quite different compared to past decades. But I think what stood out to me this time around in particular was just like the sheer partisanship of that opposition, right? Partisan team play. It looked really like tit for tat coming from the Republican delegation on the conference, on the Judiciary Committee, right? Sort of quite vocal about kind of payback from the Republicans' perspective, their perspective of how Democrats had treated then to be Justice Barrett and Kavanaugh. Now, the parties see those nominees and the issues quite differently, but it was just stark, I think, and quite is what I will remember, just the degree to which Republicans were really to tar Judge Jackson before that committee in ways, calling her a pseudo pedophile and so forth. I mean, I guess that's jumping the shark, right? Really going places that I don't think we'd quite seen before in that confirmation process.
So let's talk about that, Sarah, because you've talked and written about how, confirmation hearings have become more political over the last few decades, and at least in the sense that nominees are receiving fewer votes from the party opposite to the president who's doing the nominating. I mean, considering that context, do you think that, were you hopeful that this confirmation process was going to go a different route? I mean, especially, you mentioned Justice Kavanaugh. I think he said, he sort of forewarned in his confirmation hearing that what goes around comes around. I mean, is that how you viewed this?
For sure. I mean, but we've seen this, as you suggested, right, in confirmation politics, not just at the most important top level here of the Supreme Court, but for 2, 3, even decades at the lower federal court, first over the appellate court judges, but also about increasingly on district court judges who conceptually aren't necessarily really making a lot of ideologically charged decisions. So this notion that your party did it first, we're going to do it next. I mean, we see that both in filibusters, both in withholding of what we call the blue slips, slowing things down in committees, right? Each party has been quite explicit that it is payback time. I would say probably a little more explicit on the Republican side. Democrats tend not to quite be quite so blunt about it. So in that sense, it's not surprising, and it mirrors what we've seen elsewhere, both in Congress and more broadly in the party system. As these parties, the stakes have become quite high for reasons we can get into, as we can see in last week's story about Roe v. Wade. But in that sense, no, not surprising at all.
I was a bit shocked, though I expected it, and I wasn't surprised by it. I was a bit shocked by the approach that some of the Republicans on the Judiciary Committee took, in part because this was a historic nomination, and Judge Jackson is the first Black woman to who will be serving on the court. So, I mean, Fatima, Chris, I mean, how do you, given that the president and White House officials, they started with a principle, then they were narrowing down to a short list and an eventual nominee. Do you think that they considered these types of issues in that selection process, or do you think that they took for granted that this was going to be an ugly and a messy process? And what I'm thinking about is, particularly in the context of other shortlist candidates like District Judge Michelle Childs, who potentially could have attracted some bipartisan support.
I have to say, one thing I just to go back a little bit, that I don't think it's a fair reflection to sort of say tit for tat, because we are sort of in a time where there there were effectively, with no information or evidence, implications of pedophilia or her being a pedophile. Like this is, I think we do a little bit of harm. And I think the senators actually, in watching the hearings, did a little bit of harm in not pushing back at all at the process objections that were being raised to suggest that there were things that were typical about the Justice Kavanaugh's nomination and hearing, or that they had handled that appropriately, or even things that were typical about holding over Merrick Garland's nomination and refusing to fill the seat, and at the same time then confirming Justice Barrett the month before an election after people had already voted. So like I actually was frustrated that there wasn't a process debate, which I know the public is probably deeply uninterested in it, but I'm actually interested in, like, let's have a clear record around it. But the level of attack, everyone understood that the first Black woman on the Supreme Court would face racist and sexist attacks. I mean, I think we were prepared for that. We saw it come up in practice, in my view, in the nominations of Vanita Gupta and Kristen Clark to lower level positions in the Department of Justice. No one even knows what the associate attorney general does, but there were $1 million spent in a campaign against Vanita Gupta. And so we expected that. I did not expect this sort of QAnon-esque piece that is sort of dangerous to find its way in a Senate Judiciary Committee room. I think that is what has thrown me off. And it says something about the campaign, the political campaign we can expect to see this fall. But it also, I think, says something about how fundamentally broken our process around judges is.
Chris, do you want to add to that?
I mean, I will add, like, on the one hand, it wasn't surprising. On the other hand, like, it really was, like, the lengths, as Fatima said, the lengths at which they went was a little bit jarring. But I also think part of this is, like, Republicans go out of their way to gaslight us, or to sort of the hypocrisy. They open the whole thing saying, we're going to be extra respectful. We're not going to do what Democrats did to Brett Kavanaugh. First Black woman, we're going to treat her respect. And then that's what they came back with. This is, and maybe that's how Republicans treat Black women with respect. But like, that was just jarring. Like, that is what Republicans say one thing. I think Democrats take it on face value that they're going to treat the nominee fairly. And I don't think that that's right. I don't think that the history bears it out. And then on the flip side, I think you see Democrats going out of their way. They went out of their way to be courteous to Judge Barrett. Even though it was a party line vote against her, so many people grounded in the process and the timing, rather than coming up with, what I just, the conspiracy theories and sort of the length that the Republican Party has gone to then smear Judge Jackson with them. It was appalling. Even though, we were ready for it, sort of intellectually ready, that the racism and sexism were coming. And I think the White House was ready. I certainly think the White House was ready. But also, like, look at who the White House picked. They picked a judge who was sitting on the second highest court in the country, who less than a year ago received bipartisan support. They were trying to find people who they thought could be confirmed, even in this politicized environment. I think that the credentials and the hearing that Judge Jackson engaged in proved that, by even getting Senator Romney, who opposed her for the DC Circuit, to support her for the Supreme Court. Like, that's the kind of nominee and justice she will be. And I think that is what the White House was looking for. But I think that at some level, it just doesn't matter anymore. I think Republicans have gone so far to their base so dramatically that even senators that you might think were more reasonable than others let their Republican colleagues run with these conspiracy theories, run with this and pretend that there was something there. I thought the whole thing was appalling, to the point that it really makes me question whether or not we should even bother having hearings if this is what they're going to devolve to.
Well, and it's worth remembering that at a critical moment in Justice Kavanaugh's confirmation, it was a Republican senator, Jeff Flake, who supported further investigation into the allegations by the FBI. So I guess off of that point, I mean, that's a pretty sad assessment of things. I mean, looking forward to how there is some hope for improving this process moving forward. I mean, Sarah, have you thought about what changes could realistically be considered and implemented to this process in the future that might make it a more deliberative process that occurs in good faith?
I mean, I think it's an excellent goal, but I really think it's swimming upstream in a serious way to think that there could actually be improvements here. I mean, I think the as we've sort of been talking about, the problems is that the process, the advice and consent here, the vetting and so forth, takes place in this hypercharged partisan environment. And the parties have an incentive, especially the out party, to really probe these nominees and to use it as fireworks for things independent, unrelated to the nominee, right? To their party agenda on issues, to their party's interest in raising money, for individual senators' interest in carving out their own paths to running a campaign for president and so forth. So in that environment, I just think it's very hard to find the room in which one might have a confirmation hearing that sort of was closer to what its intent was of securing information, right? Well, as we think of it, this is our moment of accountability, right? Prospective accountability, right? What do you want to ask in order to learn about what the just or how the justice is going would rule and write opinions? I guess the one thing to think about is that we know before these most recent nomination hearings is that these hearings have not been great for elucidating information, right? Because most of the nominees say, well, I can't, and perhaps appropriately, I can't comment because the case could come before the court. But I think there'll be a new kind of dilemma or challenge here, given what seems to be happening with the Roe v. Wade case on the Mississippi case, right? These charges from Collins, or soft pedal charges from Senator Collins and Senator Murkowski, that perhaps they weren't told the truth by the nominee, by Kavanaugh, and in particular in Gorsuch. Which will just discourage any more elucidation of more information from the nominees. And the only alternative is to do them behind closed doors. And I don't really think that's really going to happen, because it undermines all the players and the individual senators' incentives for having a public hearing in the first place. So, I mean, if we look to other solutions we find in the confirmation process are not going to work for Supreme Court, right? We've seen the pairing of nominees, right? A Democrat and a Republican. We've seen slates of nominees, but neither of that can at all be applied to the particular difficulty of confirming Supreme Court nominees.
Yeah, following the Justice Kavanaugh confirmation, there seemed to be a moment where folks were willing to consider at least potential changes to the background investigation process so that it wasn't solely controlled by the White House, not just the fact of the investigation, but actually the scope of the investigation and who investigators could speak with. And that's something that, I personally advocated for, as some of you know, but that ultimately didn't materialize. And I'm not sure that there's an appetite for any other changes, as you're saying. Shifting gears a bit, I do want to talk about a bit more about Judge Jackson's impact on the court, even if she is not going to shift the balance of power on the court. And, we got to this a little bit at the very start, but excuse me. Fatima, I'm wondering, could you talk a bit about what your expectations might be in terms of how her future on the court may alter either the arguments, the deliberations within the court, or might otherwise moderate certain views or contribute to any additional shifts in thinking by the other justices?
Well, I also think we have to keep in mind that it will also mean that for the first time in history, we will have two Black people on the court at the same time with deeply different approaches to how they think about the Constitution, and even the telling of history. One of the things that has been really tough, at least for me to read over recent years, is some of Justice Thomas's dissents, where he really claims a mantle of Blackness, and as the one with authority to name a Black experience. And has done that specifically around abortion and on other issues too. And so having multiple people there who are able to have personal claims to understanding experience and history around Blackness, I think will be important. I also really do think, we won't know until she is there, but the opportunity to both shape around the edges and contours of the decision. We all got an insight in this leaked draft. And I am expecting lots of folks to do line by line comparisons from whatever the leak is to whatever the final is, whether or not the six remain together. And there are things in that leaked draft that were, blow you away appalling, right? Like the references to 13th century and the reliance on the culture and norms of the 17th century when you're talking about an issue that so deeply impacts women in the context of what their experiences and rights were in the 17th century. Do those types of things make it in the back and forth and tug and pull? I don't know, right? But when I think about the opportunity for when Judge Jackson will be on the court, you might see an ability to shape things. And then I also, and this is true at the National Women's Law Center for sure for our broader team, is that the value of dissent to remind people that there is an alternative view and perspective becomes really important to people. I think it's why Justice Ginsburg, had her dissent collar, and there was so much cultural significance to her, the way in which she would dissent, including reading her dissents, including, direct calls to Congress to fix things that the Supreme Court does that's out of step. I actually think there's a bunch of ways, even if you don't find your way in a numerical majority, to shape it in the short term.
Look, and I think that's absolutely right. And not to be overly simplistic, but the children's story that I read to my kids is "I Dissent," right? That's the title of the story, and there is meaning to that. So, okay, now I'm going to get to the largely unprecedented and perhaps politically motivated leak in the Dobbs case, which obviously would represent a seismic shift in the court's jurisprudence and approach to privacy and abortion rights, and just have huge implications for the American public. Now, I think the leak itself calls into question how the court functions internally. But even before the leak, the Wall Street Journal, Politico, and probably others were already reporting on the tentative vote count for overturning Roe. And I even saw in the New York Times this morning that they were reporting on the fact that the justices were meeting this morning for the first time since the draft opinions leak. And I almost feel like we're getting to a place where it's like an ESPN-like play-by-play situation where, it's the familiar kind of reporting that you would expect for the other branches of government, but not for the court. And so I think we should just talk a little bit about what that means for how the court works behind the scenes going forward, and how it interacts with the other branches of government. I could pose that question to any of you. I mean, who wants to jump in there?
So I'll jump in, but hope we won't dwell too much on the leak, because I think so much of the focus has been on the leak and not enough on the substance of the draft opinion, sort of depending on the circles you are, and I think that's intentional, that is certainly where the Republican outrage has been. Here's the bright, shiny object of an unprecedented leak, as opposed to the substance and the impact that this is gonna have on millions of Americans. But I also think, I think these leaks are a good thing. I think that these leaks are revealing the judiciary as being a political body. The Supreme Court is political, not just Republican, Democrat political, and it is, and I think we have to. I think progressives have been very slow to recognize that this draft opinion is the culmination of a 50-year effort by Republicans to politicize our Supreme Court. But it's also political in like a smaller way. Like I think about the reporting that came out around the decision to uphold Obamacare, right? John Roberts traded his vote to uphold Obamacare for two liberals voting to strike down the Medicaid expansion, right? That feels very legislative jockeying of like back and forth trading votes, and not this idea that there's only one interpretation of the law. And that is the reality. The reality is that the courts make these decisions based on things that are not just what happened in the 17th century, as if that should ever be the way in which we interpret the law and the Constitution today. But I think we need to understand that the Supreme Court always has been, and especially now that there is a 6-3 Republican supermajority, is increasingly partisan, and it is a political body, and we need to start thinking about it that way in how we interpret the decisions, how we understand how the process is done, and how we react to it as a country, and how we ask our lawmakers and the president to really react to it when it comes to drafting laws and implementing regulations.
I would just add one thing, I guess, or two things to what Chris has suggested. And maybe I didn't read widely enough in the wake of the leak when Chief Justice Roberts gave his comments that this was an appalling leak, I think was what he said. But I don't think anyone really explained what made it, setting aside obviously the content and the substance. But what about the leak was appalling? And imagine one answer to that question is that there's a norm, just this very strong norm of behavior, right? They're socialized into this small community where they can expect that as they work out opinions, through bargaining, as we know, right? As they work these opinions out, that they can be guaranteed that it won't leak out, and that there's this trust that has to occur on the court. And so one possibility here is Roberts is reacting to the trust part. And it's hard for us as political scientists to know whether these is, strong trust, weak trust, like what exactly is going on. But it does seem to be the case that type of those normative behaviors have disappeared or are disappearing on the court. But the other reason one might be appalled, I suppose, if you were the chief, is that it exposes what Chris mentioned, right? That lifts the curtain, and it makes plain to folks who don't go back and read the justices' papers and discover that there's bargaining on the court. It is a small p political institution, and political scientists who have studied the justices' docket books and papers from, say, the Burger Court, we see that bargaining, we see negotiations, we see tit for tat, we see all of this type of behavior, which of course, I think justices worry about, that people are going to sort of be less supportive of the court, and it's going to diminish their legitimacy if we think that they're just politicians in robes. And we can come to this question of legitimacy, but I would have thought Roberts might have been a little bit more explicit about what the issues are with the leak, even putting aside the question of the substance.
Yeah, I mean, you got to my next question right away, Chris, and Sarah, you built from it. But I mean, it gets to this larger question about how the court is seen now as a political body, and the prospect of them overturning Roe in some ways, when you think about how they're moving away from this reliance on precedent or a super precedent, only feeds into that. And, I think it really is remarkable. Let me just share a couple of some statistics for you. But even before that, I think it's remarkable that since 1988, so almost 35 years, only one Republican president has won the popular vote, George W. Bush in 2004. But Republican presidents have nonetheless appointed 6 of the 9 justices sitting on the court. And so that, to me, has always meant that, it means that I'm not surprised that people see it as a political body. Okay, so a Morning Consult poll taken following the leak showed that Americans now support term limits for Supreme Court justices by 66% to 21%. And they favor expanding the court by 55% to 36%. And 73% now say that justices should be bound by the same ethics rules that apply to other federal judges. Now, other things have happened recently that would support some of these numbers. For example, the revelations of Ginny Thomas's attendance at the January 6th rally and the text messages between her and former Chief of Staff Mark Meadows, and the fact that Justice Amy Coney Barrett refused to recuse herself from a case involving Shell, where her father worked, despite the fact that she recused herself from cases involving Shell when she was on the Court of Appeals. So what do you make of this shift that we are seeing, both in how Americans view the court, but also in terms of whether or not we should expect for greater momentum and movement toward these types of reforms to gain traction? Fatima, can I start with you?
The other thing that I would add is the justices wondering aloud about whether or not they are contributing to the public's distrust of the court. And it's not like they began to wonder that with this leak. They were wondering that around the idea when SB 8 was allowed to go into effect. They were concerned about speeches each other were making that had political tones to them. And so I do think the public is now understanding in new ways that the court is more of a political body. And for some of us, Chris talked about, like, for progressives, this was really hard. Some of us, you come up with this idea and lore where you want to believe that there, even if it's political around the edges, that you won't see sort of the brute force politics that you see in other settings. And so I don't know how there isn't an on purpose, clear conversation around how do you fix this problem? How do you deal with the fact that the public's trust is waning? And the court understands that it needs the public's trust. The court has no army. The court can, if the court is going to do things that are deeply unpopular and that go against what the public itself is saying they want, that's only going to put the court further at odds and highlight the question of who decided that these 9 people get to do this. And so I think the court itself should be asking Congress to consider what the rules of the road should be that help grow the public's trust.
I think that that's both right, but it's not going to happen, right? Like, the Supreme Court has had every opportunity to institute its own binding code of ethics on itself, and it refuses to. It's the only court in the entire country without a binding code of ethics. They could do that to increase some confidence in the judiciary. Instead, they go around, Justice Barrett gives a speech at the McConnell Center, introduced by Mitch McConnell, and says, don't say that justices are political, right? It's part of this is the gaslighting, but it's the gaslighting that then relies on people like Justice Breyer, who says, don't say the court is political. And they're relying on this sort of the lore that Fatima's talking about, this idea, I wish it were true that the Supreme Court and our judiciary was not political. But that's not the reality. And we have to acknowledge that reality, and we have to engage with that reality in order to ever correct it. I think that we're going to see this not only with the potential of overturning Roe versus Wade, but there are other big cases on the Supreme Court's docket this term as well, dealing with gun violence prevention and climate change, whether or not the Environmental Protection Agency will be able to enforce the Clean Air Act, right? These are issues, access to abortion, climate change, gun violence prevention, that are supported by 70 to 80% of the American people. And yet you're going to see these 5 or 6 Republican justices impose the Republican Party extremist agenda on the entire country. And that, I think, is going to be, we're seeing the confidence in the court crater since, in particular, the court allowed this effectively an abortion ban to go in effect in Texas months ago. I think it started it's just going to rapidly decline. And then you'll see, I think the only way that we're ever going to increase the legitimacy of the court is by restoring balance, to make sure that the court is more balanced than it is now. And that's why I think that, Rudy, as the poet pointed out, showed that Supreme Court expansion is a more and more popular reform, because it's clearly constitutional, and it would right the fact that Republicans stole these 2 Supreme Court seats, one from President Obama, and then this other one effectively stealing it from Joe Biden after 60 million Americans had already voted, and restore the balance to what it should be. And then I think we can sort of figure out how the court can earn its legitimacy back. I think part of the challenge is that, you know, the court is trafficking legitimacy that we all wish it had, instead of really deserving it in the first place.
So, I mean, I wonder, even despite the growing support for those kinds of reforms, how optimistic you are that they'll actually gain some traction. I mean, I think Senator McConnell has already said that should he find himself in the majority again, that it is very unlikely that he would seat in 2024 another Supreme Court justice nominated by President Biden. And I also, I'm wondering what is stopping him from taking that same position, for example, in 2023. And so is there reason to think that maybe some of these reforms will gain traction and perhaps win allies in places where they don't currently exist?
Well, and I just want to say, I don't think that there's any principled rule that he is articulating about when to take on a Supreme Court nominee. And so I think if there is a Supreme Court nominee and he is running the Senate, I think we know what the outcome would be. That person will not move forward. And I think he's letting us know there will be a new rule. But in terms of the public understanding and support for how do you fix the court, right now, we can't even get the sort of energy around some basic ethics reforms. And I actually think that is telling. I think it is telling in part because if we can't even understand how to have greater clarity and a set of rules that bring legitimacy to the court around their own ethics, then it raises the whole question around what are the steps that we need to take, really, frankly, to reduce the court's importance. I mean, it's very much connected to the points that Sarah made early on, that, right now it seems like there's no real fix because you have a party in charge and an opposition party, and there will have to be campaigns run on each side. And part of it is the stakes that are there for a generation. And it is highly unusual to have had the situation we did where one president has 3 nominees in 4 years, right? Part of the reason that happened was, as Chris said, that 2 of those processes were so deeply problematic in terms of the timing. But ordinarily, we can't expect that sort of shift. So as long as there's a perception in the public that the only difference is the personnel in terms of the outcomes for this court, I think people will keep raising that there needs to be a real and meaningful fix.
So we are really talking about the Supreme Court in the next, 20 to 40 years of our country, either playing a different role than people have expected it to play, or that it has played in the last couple decades. And I think about the draft opinion. Alito goes to some lengths to try to distinguish this opinion from other rights that the court has secured, whether it's same-sex marriage or something else. I mean, what kind of impact might that have in how the court functions just generally within our democracy. Sarah, do you have thoughts on that?
I have
And I guess I ask, maybe I'll have
Yeah.
one amendment to that question. I mean, how should we take Justice Alito at his word? Like, should we have confidence that he won't scale back these other rights because of the distinction he makes in that draft opinion?
I would not take him at his word, but I'm going to leave that for the legal scholars to probe. This is more of an indirect answer to your question about consequences of, or what could come at the court with respect to these other rights, reversal of other rights. I think one thing we haven't quite focused on just generally, although it's premature perhaps, is to think about what the impact will be at the state legislative level in response to, first of all, to an impending decision on the Mississippi case, but also potential other cases that may spill from it. And state legislatures are not all quite as polarized as Congress is. It's pretty big gradient from very polarized to not so polarized. But we know that obviously the red states look quite differently in their priorities than blue states. So one question I think I have going forward is, what does the legislative process and the targets and the priorities look like in blue states versus red states in response, in the short term, in response to the Mississippi case? I mean, I would expect blue states to move pretty aggressively to broaden and in whatever form to codify or put into state constitutions more reproductive right freedoms and to try to solidify any other rights that they may think broader health rights and so forth. At the same time, we would expect to see the Republican legislatures were sort of already getting whiffs of it, more pretty dire, pushing, contraception bans and so forth. So, but those politics are going to generate a politics in the state as well. And the question is, how well or what do each of these parties do? How does the public react to extreme movement certainly on the right side at the state level, to change people's perceptions, to understand what's at stake here? So I think we don't quite know how those will spin out, but I do think it will affect what future cases come back up to the court.
Just add, I mean, there's some things that are even more complicated around it. There are a number of states that have what everyone calls trigger laws that go into effect the moment Roe isn't decided, and not all of those would consider themselves to be red states. You know, people in Michigan didn't take a vote in modern times around whether or not they wanted to have abortion banned. And so the fact that the sitting governor is having to file a preemptive suit to block an implementation of what 2 generations of people in the state of Michigan have come up with. It just shows how alarming it is. The other thing I think is really important to think about is that this is really going to be the first time in our history where a fundamental constitutional right has been rolled back. There have for sure, and if you read the draft opinion, Justice Alito names the times when there have been decisions that have been overturned. But we've been a country that has been around expanding individual rights. And so the idea that the public should just get on with it and leave it to the states, it's not how we think about our fundamental constitutional rights. And even the language of leaving it to the states, which is a thing that I think you'll hear a lot more of, like it's just fine because we're going to leave it to the states. The leaving it to the states means that you're going to criminalize and punish doctors and providers. Leaving it to the states means you're going to mean that people are going to have to travel thousands to get what should be constitutionally protected healthcare. And leaving it to the states will mean that all of us, in terms of how we think about our fundamental rights as being secure, that bare basement threshold, which was many of us thought Roe was, that those things aren't going to be very secure elsewhere if there are states that would like to undermine them. So that's true for contraception, where you're already seeing efforts. But I think we're going to see that come up in other places where there are still states disagree. I thought we had a civil war where like that was resolved, and then we decided we were one country with constitutional floors, and this all is being relitigated again.
I think that, you know, the other concerning pattern that seems at least to be occurring is this effort to prevent residents in one state from even going and seeking an abortion or exercising their reproductive rights in another state, and trying to penalize them for that. And the other thing that I think is striking about that is the uncertainty that the Supreme Court's current path creates for, you know, sitting lower court judges in terms of how they try to guess how the Supreme Court might rule on a future opinion, but also for future judicial nominees. You know, I think, Sarah, I think you mentioned what Senator Collins said about the commitments that she thought she had from sitting justices. But it seems like if the judges, the existing Supreme Court justices are going to make it harder for future nominees to be taken at their word, and are actually further politicizing the process. But getting to this point about lower courts, Chris, I know that you do some work on the role that lower courts play and their importance. I mean, do you have concerns about the repercussions in terms of how they will handle future cases?
I mean, I think we're already starting to see it play out from the moment that Justice Barrett was confirmed, solidifying a 6-3 Republican supermajority. Lower court judges, particularly those appointed by President Trump, some of them also appointed by President Bush, have gone as far as possible. They're like trying to bait the Supreme Court. It's not that there's some uncertainty. They're hoping. We have one district court judge in Texas who is requiring the United States government to negotiate with Mexico. Could you imagine? And yet the Supreme Court is deciding whether or not that's okay. These partisan Trump judges are doing what they were appointed to do, which is move the law as far ideologically to the right as possible, and hoping that the Supreme Court will either be too busy and will just rubber stamp their opinion through the shadow docket, or will actually affirmatively approve their decisions. And so I think it's very problematic. It's also problematic. We just saw yesterday a judicial nominee from Illinois was nominated to the circuit court, and Republican senators criticized one of his decisions regarding COVID restrictions. His opinion was actually upheld by the Seventh Circuit. This wasn't him going off and doing something lawless. The lawless thing was the Supreme Court overturning him, right? And that's how you just allow these Republicans to shape what is acceptable in the law based on what 5 Republican appointed justices say is acceptable. And I think that that's a very dangerous frame for us to be in.
Oh, sorry about that. It wouldn't be a Zoom panel if I didn't talk on mute at least once. I'm receiving a prompt here from our hosts that it's time for me to turn it back over to Sadia. So I just want to take a moment and thank my panelists again. This has been a great conversation. We could go on. These are incredibly really pressing, important, and serious issues. And I just want to thank you for the work that you all are doing and for your contributions to these issues generally, but also to helping us and our audience better understand these issues and why we need to be paying attention to them and what they mean for the future of our democracy. So thank you very much. And Sadia, I'll pass it to you.
And thank you, Rudy. I'd like to thank you for moderating today's conversation, and our amazing panelists as well. Chris Kang, we didn't note that you're a UChicago alum. Thank you so much for joining us virtually and being back on campus. We hope hope you'll all join us for future events and continue following the work of the University of Chicago Center for Effective Government's work. We're housed here at the Harris School of Public Policy, and you can find more information on our website, www.effectivegov.uchicago.edu, and by following us on Twitter at uChicagoCEG. Special thanks to our friends and partners at the Democracy Fund for co-sponsoring this event, and to all of you who joined us virtually. This event was recorded and will be hosted on the University of Chicago's YouTube channel. So thank you so much. Have a great afternoon.